Connecting our courts to a stable and reliable internet has been a key and a primary objective, as this forms the basis for other technology-based strategies for service delivery. At the start of SGIT in 2017, only 34 courts were connected to internet. Over the last 4 years, this number has since grown to 147, which has enabled the judiciary to implement a number of solutions, especially during this period of coronavirus pandemic. Having previously made false attempts at automating our proceedings and digitizing our records, from the 1st of July this year, we made a bold decision on advice of the technical people, and started the e-filing system in all courts in Nairobi and the environs. The e-filing system, which is part of the strategy to leverage on technology for efficient and expeditious service delivery, had initially been piloted at the commercial division of the High Court. Since then, almost 3,000 law firms have registered onto the system. Over 20,000 new cases have been filed, and over 250 million Kenya shillings in court fee collected through the system. I must admit, we are currently experiencing some system challenges, but these are teething problems which are associated with such a huge new system. I want to thank the Law Society in particular for their continued support and encouragement in this regard. Even as they raise their challenges and complaints, they are steadfast in their resolve that we are not going back and that we should continue, and I want to thank them most sincerely for that. The challenges are continuously being addressed, and I'm sure we will soon overcome. As soon as we complete the ongoing recruitment of more ICT staff for support, the system will be rolled out to all parts of the country as soon as possible. While the current measures to combat COVID-19 resulted in downgrading of in-person court operations and other measures geared at placing the pandemic under control, the leveraging on technology has enabled us to continue offering service to the Kenyan people. So you can see how important technology is for our service delivery. I'm confident that these achievements, as well as several other components of judicial digital transformation, which are captured in the Judiciary ICT Master Plan, will be progressively implemented to facilitate the enhancement of access to justice. Despite the progress and the steps made in the years of operation of SGIT, I must point out that we have achieved some of the above enumerated results under fairly difficult circumstances. The judiciary's performance would certainly have been different and a lot better, but for 3 reasons: interference with and frustration of the judiciary's independence, refusal to grant the judiciary financial autonomy, and disobedience of court orders. It is indisputable that during the former constitutional era, like it was during the colonial era, the judiciary was an appendage of the executive. Although the Independence Constitution textually embraced the doctrine of separation of powers and provided for an independent judiciary, that separation was only on paper. The judiciary remained substantially at the call and beck of the executive arm of government. The history of that subservience is well documented by legal historians and government experts. This judicial subservience has serious implications for individual liberties, human rights of citizens, shared prosperity, and even economic development of the country. It is, in large part, this subservience that triggered Kenya's clamor for a new constitution and a demand for an independent judiciary, both in the letter and the spirit of the law. As the reports of the Constitution of Kenya Review Commission and the Committee of Experts demonstrate, Kenyans deeming judicial independence an imperative for it to effectively discharge its mandate, created one in Chapter 10. It is this single-minded demand from Kenyans that culminated in the enactment of provisions such as Article 160 of the Constitution of Kenya 2010, which provides that in the exercise of the people's judicial authority, the judiciary shall be subject only to the Constitution and the law, and shall not be subject to the control or direction of any person or authority. As regards the appointment of judges, Article 166(1)(b) of the Constitution states that the President shall appoint judges in accordance with the recommendation of the Judicial Service Commission. Despite this clear provision and 3 court orders, the President has failed to appoint the 41 judges, now 40 because one of them has since died, unfortunately, recommended to him by the Judicial Service Commission. Article 166(1)(b), and indeed the entire Constitution, does not require the President to perform any other act upon receipt of names recommended by the Judicial Service Commission, but to appoint them. Both the High Court and the Court of Appeal have been categorical that the President has no residual legal power to question or reject the names recommended to him by HSC, but to appoint them. The President cannot cherry-pick from the list of nominees. If that is allowed, ladies and gentlemen, the independence of the judiciary will be irreparably ruined, and the presidential mischief and patronage in the appointment of judges that was prevalent under the old Constitution, and which is precisely what the new Constitution sought to remove by these new provisions, will effectively be restored. If indeed there are any of those nominees with integrity issues, as it is being alleged, which were not brought forward at the point of their open and public interview, this very Constitution has a mechanism for dealing with them. That is, to appoint them and lodge complaints with the Judicial Service Commission for their removal. In any case, since the promulgation of the Constitution 2010, the Judicial Service Commission has referred a total of 7 judges, some of them very senior, to be investigated by tribunals. Some of these decisions have been made pursuant to the petitions by very ordinary people, meaning that a factual petition by the President would definitely be promptly investigated and acted upon according to law. The history and the record of JSC of acting against judges when presented with facts demonstrates that the constitutional mechanisms for dealing with any claims of integrity against judges is working, and the invocation of non-disclosed claims cannot be used as a barrier against the appointment of any judges, particularly when it runs afoul the Constitution and violates the very well considered and rendered court decisions. This failure to appoint the 41 judges is clear interference with the independence of the judiciary, with the result that backlogs in our courts have continued to soar. I continue to urge the President to appoint those judges without any further delay. If we had completed the appointment of those judges, the JSC would have immediately embarked on the recruitment of 30 High Court judges as per the request by the principal judge of that court after its assessment. The Court of Appeal, which is currently operating at half its capacity and accumulating backlog as a result, would be fully operational and decentralized. The long outstanding land and labor cases that continue to violate people's property rights and undermine vital agrarian-based economic activities will not abate unless the Land and Environment Relations judges on that list are appointed and sworn in. The cost to Kenya's productive capacity by the continued refusal to appoint these judges is incalculable. Its cost to our reputation as a country governed by the rule of law and the known precepts of constitutionalism damages the health of our democracy and its institutions. Financial autonomy is a critical aspect of judicial independence. For it to effectively discharge its mandate, the judiciary requires not just adequate financial allocation, but also financial autonomy. Currently, the judiciary lacks both, as only 47% of its financial requests are funded, and the executive has failed to operationalize the judiciary fund. Somebody get me some drinking water. Thank you. Sorry for that.